Welcome to Burns White, Inside the Law, a podcast about the law and the people behind the practice. I'm your host, Ahsan Jafry. Inside the Law podcast. Today we are joined by Courtney Barbicane, who is a partner at Burns White, and also Kathleen Satola from U.S. Acute Care Solutions. How's everybody doing today?
Great. Thanks for having us.
All right, so I'm going to start by a few intros. Courtney, why don't you go ahead and introduce yourself to everybody? I mean, I know you well, obviously, and Kat and Kitty knows you well.
Yes,
but
unfortunately.
For everybody else who doesn't know you as well, why don't you go ahead and tell us about Courtney Barbicane?
Okay, so I graduated from law school in 2008. I almost forgot there for a second. And I immediately went into defense work. And then I was in defense work for about 4 years. And I was given the opportunity to specialize in medical malpractice at a plaintiff's firm, which I jumped on because that is my passion.
Medical malpractices, right?
Well, medicine.
Medicine, right.
I love to basically educate
That's
myself.
That's why I cleared that up for the viewers.
Yeah.
We were like,
so it wasn't really
plaintiffs here. No, I'm kidding. I'm kidding.
So it wasn't really about whether or not I was on the plaintiff side versus the defense side, as long as I was dealing with medicine and handling those types of cases, because that's what interests me. And so I worked there for about 5 years, and then that firm eventually dissolved, and I came to Burns White. So I've been here now for over 10 years.
Okay.
Have moved up the ranks, so to speak.
You certainly have, and we'll talk about that.
Thank you.
You're a rising star. Actually, you've already risen at Burns White.
And just as of recently, I've now gotten licensed in a couple other areas, including Maryland and D.C., so kind of branching out a little bit further, but still, ultimately specializing in medical malpractice and elder care and those types of cases.
Okay, so you started with Burns White. What year was it? 2000?
2000. My goodness, when did I start?
So 10 years ago, so 2015. Okay,
yeah.
All right, okay.
Actually, August of 2015.
Okay, and from day one, you've been doing the medical malpractice claims, right?
Almost predominantly, yes.
Okay. At what point did you start kind of like feeling comfortable like handling your own cases and being responsible for like your own clients, that kind of thing?
Well, it's funny because without naming names, one of my prior employers before I came to Burns White used to hand me a stack of medical records that could be like literally thousands and thousands of pages, and he would put it right on my desk and say, "Find me a case in these records."
Okay.
And so that was probably the beginning of, when I was able to start drafting my own complaints and formulating the thought process of what do I need to have a legit medical malpractice case. And then I came here and, I was given the opportunity. I started as an associate, and then I moved up to Counsel. And then, as you know, there's, different levels of the partnership. But I've always kind of been given the flexibility and leeway to handle cases almost from inception to completion here. And in terms of, how comfortable it is. Sorry. Yeah,
it was Bill.
Okay.
Okay.
I've always just been comfortable doing that. But it's important to me because I like to be very involved in those cases. It's not something where, I want somebody handling, an entire aspect of depositions and then I have no idea what's going on at the end.
Sure, right, yeah. And you were elected an equity partner, was it 2 years ago? Was that right?
Yeah, I think.
So you're at the highest level now of partnership here at Burns White.
I am.
Good for
yes.
you. Good for
Thank
you.
you.
I voted for you. Just so you know,
thank you.
Yeah,
yes.
It's a secret ballot. No, I'm just kidding.
Yeah, so I am now an equity partner, and I love it here.
Okay, and your path is not unique. I think there's been other people here who have given the chance to take on, responsibilities that young lawyers don't normally see at other firms.
Yeah, and I think that somebody had said, once you become an equity partner, do you feel like you've plateaued? And not only was my decision to get licensed in other places based on, I do want to continue to grow and learn additional things, and it was also client-driven. But it was, I don't want to be seen as plateauing just because I'm an equity partner, and I don't want to be bored in my job, and I don't want to, do just the same thing. So
there's always more out there,
yes,
right? There's
exactly.
Always, just in life in general, there's always more out there, and things are always changing.
Yeah, and you think that you know everything in your own state, and then you come to another one, and it's a whole different ball game. So
yeah, and I think what happens
keeping me on my toes.
It's like you feel like the sense of achievement, but then you feel like, okay, that lasted a day, and then you realize that there's a lot more to the job now that you didn't necessarily.
I'm like,
everything's your responsibility now. Well, good for
exactly.
you. You're handling it well.
Well, thank you. I'm trying as best I can.
And just to recap, your practice focuses mostly on the defense of medical malpractice claims, right?
Correct.
And you have wonderful clients like
Kitty Satola.
Kitty Satola.
Yes.
Absolutely.
So, Kitty, now that you learn more about Courtney, why don't you tell us a little about yourself?
So
I mean, I know you know Courtney already, but you know,
yes,
like,
yes.
What did you know
I
about
learned
her?
all kinds of new things.
Do you know about her like beautiful singing voice?
I did not know about that.
Yeah.
Are we going to have a sample?
She is the star of the Burns White Christmas party that we had a few years ago when we had karaoke. You know, like what happened was like you know how karaoke goes, right? It's that like Courtney sang and everyone's like, all right, we'll just watch Courtney now, you know, like.
Setting the bar way too high.
So Kitty, sorry.
Well, I don't do karaoke. My voice does not carry. I'm not as fortunate as Courtney. But my career path also was maybe a little bit less traditional. I am also a barred attorney. I went to law school in Massachusetts and am barred there. But I don't practice anymore. So I also had a less traditional law school experience where I went to school at night at New England Law Boston, and during the day I worked for a plaintiff side med mal firm, and it was an amazing experience. It was crazy because you're learning the theory of civil procedure in the classroom, and then I'm going to work and seeing how it actually plays out in real life. So that was really great, and really introduced me to the world of medical malpractice. I loved the intersection of medicine and law, just like Courtney does. I think it's fascinating and a really interesting and unique place to work. I didn't love working plaintiff side. I felt like it made me a little bit cynical, a little bit cold, a little bit unsympathetic. But that's just me.
I already done my plaintiff bashing already. Like I'm not gonna do it. I've already done that. I would have had more to add, but I'm like, I'm limited to one insult per podcast. Apparently, that's what they told me.
Well, we've already surpassed that.
We're way ahead of schedule. So interestingly enough, as I was studying for the bar exam, that's where I met my husband.
I was going to get into that. You beat me to it.
So he was sitting in front of me during bar review, and it's kind of a stressful time. But I ran into him shortly after the exam. We figured out how we knew each other. We started dating and we got married, which was great, except also we were both practicing in litigation space. So when you're thinking about, when you're getting married and you're thinking about starting a family, it kind of raises, time management problems.
Sure.
And it's kind of hard to have two litigators trying to raise tiny humans, right? So we were at a point where I looked around. I had been working in insurance defense, and I looked around to think, where else can I use the skills and talents I already have, maybe in a different way that's more, traditional to 9 to 5, that would be, better fitting for my lifestyle at the time. And I started working for a commercial carrier in the claims department. And that was really great and fascinating and different. So I was used to, I'm in insurance defense, and I'm telling people what to do and how to do it, and then going into the corporate world, and it's just a very different environment. I think we were talking earlier, when you're a lawyer, you're using as many words as possible and explaining as much as possible, but in the corporate world it's very different, where it's more succinct, it's more bullet point oriented, and there's different metrics for success, and it was just a really different environment, but a really cool way for me to get into claims and learn about it. After I worked for the commercial carrier, I then went to work for a hospital system, again doing claims, but from a different perspective. And from there, I ended up at U.S. Acute Care Solutions.
Okay.
I love working there. I've always enjoyed working with healthcare professionals, but some of the frustrations I had working for commercial carrier were that I would get to know these physicians and I would get to know their story and what happened in the case, but a lot of the times I had my hands tied about how we could or could not settle cases based on how the commercial carrier would view and value claims. Mm-hmm. I think when I worked in the hospital system, I had less exposure to the doctors, and working with the nurses and the administration was rewarding, but you didn't have the same level of complexity that I find interesting that you do with the physician workload. At U.S. Acute Care Solutions, being a privately held and physician-owned and operated entity, it's really great because I've been encouraged to really lean into the support of our physicians and really have a creative way to look at and evaluate claims. We don't really start with standard of care. I think what I was traditionally used to seeing with the commercial carrier is you start at standard of care and then you look at causation and then you look at damages. But I think that that's maybe not the best way to look at claims because we have to acknowledge that plaintiffs' counsel work on contingency fee basis. So they've already looked at standard of care and they've already looked at causation before they've filed a complaint. So they're not going to get paid unless there's something they can sell to a jury in there. And I think when we ignore that fact, we do a disservice to ourselves and our physicians and the APPs we support. So what we like to do is really look at what kind of case are we talking about? Is this a delay in diagnosis and treatment of a stroke? Did we maybe not set a bone properly and quickly enough? Or is this a mismanaged labor and delivery? Because those kind of fact patterns all have very different values associated with them. And so what I try to do is get a sense of the value of the claim first, and then go back to standard of care and causation to chip away at that valuation.
Great. Well, obviously, there's a lot of information you gave us. So let's recap for a second.
Yeah.
So, met your boyfriend / husband at the bar exam.
Yes.
Okay. And you've been involved in claims management in the medical malpractice space for how long now?
Oh my gosh. Let's see. Probably about 15 years at this point. Yeah, give or take.
Okay. And it seems like you've had a good variety of different types of medical malpractice claims that you've had. You mentioned the hospital space, and I know now we'll talk about more what you're doing right now, but which is more physician based, right?
Yes,
Okay.
yes,
So-
the work we do here is more specifically emergency medicine, some hospitalist medicine, but when I was working previously, I've also had experience with a lot of oncology cases, a lot of neuro cases, a lot of OBGYN.
Okay.
Those are practices, I think. I mean, Courtney, what do you think? Those are high.
Well, also, I've met you in the behavioral health space.
Oh, right. Oh, my gosh.
Hey.
I'm suppressing that because that was...
Yeah, so you've been around when it comes to the
that's
medical
difficult work. Yeah.
So we have a unique chance here, and that's why I invited you to join us. We have a good chance, I think, just to give the listener some insight as far as what makes it for claims handling from both our perspective from the law firm and also from your perspective, that you've seen both sides of it, but and it's your chance to be honest with us and tell us what you're looking for, that kind of thing. Before we do that, tell us a little bit about your company, U.S. Acute Care Solutions, or is it USACS, right?
I've heard it both ways, but it's U.S. Acute Care Solutions, but informally known as USACS. We're a physician-owned and operated company. It's privately held, and we provide physicians to emergency rooms and some hospitalist positions across the country from New Hampshire to California.
So you work, so that's a company, and you work within claims department for that company?
Yes.
Okay, all right. So are you working for a company that is, what I mean by that is, just so everybody understands, is it a company that just purely does claims, or is it you're in the claims department within that company?
So it's kind of like an in-house position. So
that's
U.S.
exactly
Acute Care
right.
Solution is a holding entity, a branding kind of name, and within that company are different subsets. So I work in the claims department,
Sure.
And then there's in-house legal, in-house tax, and then the employment of the physicians themselves through separate entities.
And it's physician owned.
Yes.
And all the physicians are essentially emergency medicine, is that what you're saying?
Primarily. There are some hospitalist / observation positions, but the majority would be emergency medicine.
Okay. And what is your role as far as claims? How do you handle it?
So I'm director of claims, and so the claims department sits under the legal department.
Okay.
And above me, I have Dusty Otwell. He's our VP and Chief Risk Officer.
Does he mind you mentioning his name?
I hope not. No, he's also done some podcasts as well, so
Okay.
I can't imagine he'd be upset. So I sit under him, and then below me I have claims managers, and then below my claims managers, we work with a TPA that provides kind of that ground level, claims, adjuster kind of role.
Okay.
And then my claims managers are more responsible for strategy and global decisions, and then I will sit over that as a more, if you're talking to me, something probably pretty bad has happened.
Well, I guess through your role, you interact quite a bit with defense counsel.
Yes.
Such as Courtney,
yes.
right?
Mm-hmm.
So what I wanted to kind of focus on today was just get general ideas, things that, as in your role as a claims professional, what works, what doesn't work, and the way we'll do it is structure it like with questions like whether you love something, love, hate, and tolerate. That's how we'll do it. Okay.
Okay.
Just a few type of things that I've seen, and for the people who don't know, I do concentrate on medical malpractice defense claims as well. So that's why I like these type of podcasts where I know what I'm talking about a little bit, as opposed to railroad and other things. But they're great too, but I'm more of a listener. Like, I'm a listener always, but this I have I have some experience in this space as well. And I have a few things that I've seen, and I'm just wondering what your thoughts are, whether you love it, hate it, and tolerate it. And
maybe I'll chime in.
Yeah, and Courtney, please, yeah. For example, when you get an initial report, and when it comes to the just so the viewer, why don't you guys explain what is an initial report before we I don't want to jump ahead because some people have different backgrounds and experiences. So when you get an initial claims evaluation, what is that?
So that should be telling me what we know about the claim and what we expect to find out about the claim.
So it's like a written report kind of thing.
Yeah, it's a written report. It's like, I'm probably dating myself. Do kids even use Cliff Notes anymore? It's like a Cliff Note. Yeah. It's a ChatGPT explanation of the case. That's a better way to say it now. And
a short version, essentially.
I want to know who is the plaintiff's counsel, what venue are we in. It should, one of the things I love and look to see is my defense counsel's opinion about the plaintiff's counsel and the venue. Right, yeah. Let me
ask the question then. So, what if you get an initial report, right, and when it comes to, because I'm from the defense side, sometimes you, depending on how comfortable you are, a lot of times we are reluctant to put ourselves out there and and we hedge our opinions, So I've seen initial reports where an attorney might say it's too early to tell the damages or the damages evaluation. Love, hate, or tolerate when you see
hate.
Too early to tell.
Hate. Yeah. Hate because
that's gonna go down as hate.
It's a strong hate. I hate that because I don't think there's a reason for it. As Courtney was saying before, even if you don't have the specifics and we haven't gone through discovery, you should have a general idea of what the value of a kind of case would be. The general value of a mismanaged labor and delivery. You can estimate what the expert report is going to say, and you can give me an estimate. But to speak to your other point, I think it's important for a claims professional to build a relationship and build a trust and a safe space with the attorneys that they work with. We are truly partners with our defense counsel, and I think it's really important to. If you're going to say, I want an estimate and I understand it's going to change over the life cycle of the case, it's really important that you don't then get angry when the estimate changes over the life cycle of the case. So I think it's important to build that relationship and build that trust. But I think it's also equally important for the defense counsel to take the claims professional at their word. If I'm telling you I want something in the damages space, understanding it's an estimate, then you have to give me something in the damage space and trust that I'll understand it's an estimate.
Courtney, what do you normally do? What kind of things do you do to help evaluate a potential verdict range or settlement range in your initial evaluations, especially when you don't have all the information?
Sure. So what I typically do is I look at my prior cases if I have analogous fact patterns. But I also obviously do jury verdict research, look at other cases, and I was saying earlier before we got on the podcast that recently I've been looking at marketing and advertising where, there's posted settlements online, and I compare them to the fact pattern in my very case. I actually just had a recent example where, the plaintiff had claimed that the patient has quadriplegia. Well, I saw something in a different medical record that said paraplegia, and there's obviously a big difference between those two.
Yeah.
So in terms of, recognizing that litigation is fluid and apt to change, when I do those types of valuations, I'll put in there, this is subject to, modification or supplementation, given the fact that we don't know the full extent of injuries at this point in time. I mean, that literally the difference between those two could almost double the valuation. So I either will put a footnote in there or some type of caveat, this is, why it might change, and we have to, flesh that out during discovery. But yeah, so I'm looking at basically anything I can get my hands on in terms of cases that are analogous and what they've settled for. I look at the venue, obviously. I look at the judge that's involved, if we know that yet. I look at the plaintiff's attorneys that are involved. It's kind of a whole gambit of things.
You feel like you have a safe space with Kitty?
Yes. I've known Kitty now for...
oh my gosh, forever, right?
It sure seems like that. No, I love Kitty. I don't know when I met you, but it was... Gosh,
yeah,
it was before
I was
COVID.
Still at hospital system, and it was before COVID,
And then, so I was on her defense panel for a separate health system, and then actually when she moved over to U.S. Acute Care Solutions, I basically reached out and said, "Hey, can I be on your panel?"
I said, "Of course you can. You're not already." Amazing.
Yeah. We were like, "Wait, what happened?" So she's one of my trusted people that I like to work for.
Okay.
And I think the trust runs both ways. I mean, Courtney hit on a couple of really important things that affect valuation, and that is, who is the plaintiff's counsel, and in this venue, how much is this damage worth? Because I think it's really important to acknowledge that different firms bring different cachet and different quality of cases to the table. And I think also venue is so important. I can think of states where if you go 20 miles, the value of the same fact pattern changes drastically based on the jury pool and the anticipated outcome.
I agree.
All right, let's do love, hate, tolerate again. You get an initial evaluation, and the evaluation says, we haven't had a chance to meet with the insured physician yet, but here's what you think right now with what we have.
Hate.
Like,
so I think it's really important as
these are not my evaluations.
I know. Hopefully they're not mine.
These are
not
worst case scenarios, right?
Yeah.
But I think one of the things that's really important, and one of the things that we strive to do, is make sure we're supporting our physicians who've been sued. I think arguably getting that legal paperwork is the worst day of that physician's career. Nobody wants to think it's going to happen to them, but depending on what studies you read, roughly 1 in 3 doctors are going to be sued at some point during their career. So I think there's still kind of a taboo around it, and I think physicians still feel there's kind of a smudge next to their name simply because they've been named. And I think it's really important to reach out early and let them know, hey, an allegation is just that, an allegation. And emphasize to them this happens to more doctors than you think, and to let them know they're supported and they have a team behind them. So one of the things that I really emphasize to both my claims managers and my defense counsel is timely reaching out to the physician. I like to ask my claims managers to reach out to them in 24 to 48 business hours of receiving litigation paperwork, to check in, make sure they're doing okay. And similarly, understanding that, sometimes defense counsel may reach out, but then, set an initial meeting after records are received, understanding that can vary. I think the hardest part for physicians is being in limbo. And I think that's especially true for emergency physicians. Having worked with a lot of different specialties, with emergency room physicians, everything they do is fast. And everything in litigation is 100% the opposite of that. It's very slow. So I think being able to have somebody to talk to and feel like they've started the process. I mean, they have started the process, but giving them someone concrete to speak to, giving them a sense of security is something that we really value, because an upset, angry, and scared doctor is never going to be a a good witness on his own behalf, is never going to be a good advocate for himself. And opening that door and raising that comfort level so the doctor can be frank with you. Hey, I had worries about X, Y, and Z. Do you think that impacts this case? Or, hey, I feel very strongly that the care I gave here was good. Understanding how the doctor feels and perceives the litigation is a really important first step to being able to support them and get the best result possible for them.
Courtney, what is it that you feel like you try and do to make sure like an insured or a physician is comfortable pretty early on in the process when it comes to a case?
So typically, and with U.S. Acute Care Solutions, they reach out to the provider first to give them notice of the lawsuit, and then
it's not like, "Hi, Courtney Barber came out of nowhere," right?
Yes,
I'm a lawyer.
Right. Let me scare the
they paid money for you a little
Jesus
bit.
Right. But so I typically will set up a meeting with them. And in terms of availability and being able to schedule it as quickly as possible, with the recognition that emergency room doctors are sometimes coming off of an overnight shift.
Yeah, definitely.
I
watch The Pit, so I know.
Yeah. Exactly. So we have to be cognizant of their time as well, and also their ability to have an articulate, educated conversation if they're exhausted. But so that can sometimes delay the initial meeting. But
what does it feel like they feel like they want to hear from you when you first
that you're going to bat for them, that you're going to really kind of get in the weeds and go through the medical records, that you're going to listen to what they think the strengths and the weaknesses of the case are, and that you're going to get experts on board that are going to support them. And that, again, even with clients versus the doctors, I think just being responsive is so important. Just knowing that you're there and you're readily available to discuss anything if they need it. They get my cell phone numbers. They can call me whenever. I try to be as responsive as possible, but it is kind of an element of, and I have learned this in now representing and defending more doctors as opposed to the health system as a whole. It is kind of being like their friend in a sense. Yeah. And almost
and every doctor's different, right?
Every doctor's different. There are some doctors, and I don't know if this is crazy to say, but it's almost like you have to take a motherly approach to them, because you have to sometimes deliver unfavorable news to them, whether that's this expert doesn't necessarily agree with what you did, or this is not the avenue we can take for defending the case. I mean, it's like talking to your child in a sense that we have to find a way to work around it, because that is the truth of what happened.
Yeah.
You can't sugarcoat everything, but so with that in mind, I do try to be sensitive to what they are going through. Like Kitty said, it is probably the worst day of their life when they receive something like that, and it literally haunts them pretty much every day until the case is resolved. And I constantly am trying to be cognizant of that.
Okay. Well, this is a really good conversation, and we're running up against our cutoff time. So, it went by pretty fast, right?
Yeah.
Like
we just got here.
Yeah. So why don't we do this? Courtney, I'll start with you. If you had to have a takeaway message as far as what any physician or any medical provider would get from you as far as a defense attorney, what would it be? And Kitty, just to give you a heads up, I'm going to ask you something similar. Okay, from your perspective.
You didn't ask Kitty first.
Sorry to put you on the spot.
That's okay. I'm actually prepared for that, because I feel like I've had to answer this previously. Not with you, but I do really try to take a creative angle in how I defend cases. So whether that's getting the client out altogether because I find that there's no merit, whether it's on a motion. I constantly am thinking of things outside of the box to creatively litigate a case. Like I will literally wake up at 3:00 in the morning and be like, oh my gosh, I just thought of something. I'm going to have to tell somebody this and see what their thoughts are.
Do you, when you text somebody, do you like this send it later kind of thing? Do you do that?
I literally just learned how to do that.
I was just like, all right, it's 3:00 in the morning. Let me make sure they don't get this till 8:00 or something.
No, I won't forget it, because I'll still obsess about it by the time I wake up. Right. So that I think is the most important. I mean, I am responsive. I know that, and I care a lot about my work, and I think my clients know that. But what sets me apart, hopefully, I think, is that I do try to find creative arguments, whether that's on the substance of the law or procedural, deficiencies with filings. I'm going to find a way to maneuver the case to get it to the best positioning I can for the client.
Okay. And Kitty, the last thoughts from you. When you're looking for a defense lawyer and you have something in your mind as far as what I want out of this defense lawyer representing your insureds and your physicians, what is it that you're looking for?
Besides me.
Besides Courtney. But I mean, what Courtney said about creativity, it's super important. I think for too long, claims professionals have looked at claims the exact same way.
A rigid formula, right?
A rigid formula, and I think in today's environment of nuclear verdicts, that formula doesn't really work anymore.
They figured it out.
They figured it out, and it's it's just not effective. So what I look for from my defense counsel are somebody who's willing to go on a creative journey with me, to see what we can do. And then also someone who's creative in what success at the end of a litigation means, because I don't think that success always means getting a defense verdict in a courthouse. I think what success means is meeting your physician or your APP where they are. I think it means supporting them through the life cycle of the claim, even when you have to tell them difficult news or, share things that are not positive. And I think it also means making sure they are as invested in the process and as prepared as possible for every stage of the process. So when I am interviewing a new firm, some of the things I definitely ask for is, share with me your philosophy about how you support physicians and what that means to you. Tell me what you do for deposition prep. I think deposition prep is so important. We should all be treating depositions as if it was trial, because it really can sometimes mean the difference between a settlement and a trial. And I think making sure that we're preparing the physicians for those things really assertively, effectively, and early is important. I think, I can't remember if it was here or before, but Courtney mentioned about acknowledging if there's a physician who needs extra help. I think that's something that's an investment of time and money, of course, but I think it's a good ROI on that, because a doctor who appears for a deposition confidently and prepared is going to give a good presentation, and then that's going to give us options of whether or not we want to pursue a settlement, or options of perhaps this is not a doctor you want to put in front of a jury, So I think those are things that are really important to me, that the defense counsel cares about the doctor and cares about a good outcome, whatever that means for this physician.
Yeah, and then the outcome depends on the case, right?
Yeah.
All right, I think that's all we have. Thank you guys both so much for accommodating me, and
thank you.
This was so fun.
I hope it wasn't too bad. And spread the word for others.
No, it's great.
That try and get on this show.
And we'll start the new podcast, Law and Beauty Tips. Remember?
Oh man, that would not involve me at all. I can tell you that. All right. Until next time. Thanks everybody. Thanks for listening.
Thank you.
Okay. The information contained in this podcast is considered an outline intended to be supplemented by an attorney. The information is not legal advice and should not be considered as such. Thank you for joining us. If you have any questions or comments regarding this episode, feel free to email us at podcast@burnswhite.com.